Okay, hello everybody and welcome. I'm saying hello and not good morning or good afternoon because we have people joining us today from, of course, Canada, but also the US, India, Kenya, the UK, Mexico, Ecuador, Peru, Nigeria, Germany, Argentina, Colombia, and of course, the Netherlands, where the court and where our guest speaker today is located in The Hague. For Windsor Law students, I hope your term is going well. For all of our guests at today's lecture, an annual lecture series of esteemed jurists, welcome to Windsor Law. Our law school is on the traditional territory of the Anishinaabe people, specifically that of the Three Fires Confederacy. And our law school is a border law school. We can see the US from our building when we're in our building, and we will be again. And our law school lives and breathes transnational perspective on the law, including through our innovative Canadian and American dual JD program. Watching US hostility to the International Criminal Court has been puzzling from this perspective, to say the least, and alarming. On June 11th of this year, President Trump issued an executive order authorizing the denial of visas to US judges and prosecutors and a freezing of their assets in the US. It is in this context of hostility, I was going to say south of the border, but Detroit is actually north of us, that we welcome the president of the International Criminal Court to our border city law school, or we welcome him back rather, as I know he's visited here once before. And I welcome him on behalf of the faculty, students, and staff of Windsor Law, including the Black Law Students Association and the International Law Students Association, who will be helping with this event. Over the course of his 3-year term, Judge Chile Eboe-Osuji has faced numerous challenges, from US hostility to criticisms that the court focuses unevenly on Africa, to further securing the independence of judges from state parties, to getting people used to the idea that the International Criminal Court will sometimes acquit. He has steadfastly risen to meet these challenges robustly and openly, including in very public forums like this, and we are delighted to have him with us today. To introduce the president, I will ask Angela Uma, one of our second-year students, to please go ahead now.
Hi guys, I feel so honored to introduce Judge Eboe-Osuji because working at the ICC has always been something I've aspired to do in the future. So for me, this really feels like a full circle moment. So Judge Chile Eboe-Osuji, President of the International Criminal Court, has served as judge of the ICC since 11th March 2012. And he is the court's president and judge of the appeals division since 11th March 2018. Prior to joining the ICC, Judge Eboe-Osuji was the legal advisor to the UN High Commissioner for Human Rights, during which time he anchored the High Commissioner's interventions in cases involving human rights questions. In that capacity, he led the writing of amicus curiae submissions to the European Court of Human Rights and the United States Supreme Court. He served as principal appeals counsel for the prosecution in the Charles Taylor case at the Special Court for Sierra Leone, and has held several posts at the International Criminal Tribunal for Rwanda, including head of chambers and lead prosecution trial counsel. He was called to the bar in Nigeria, Ontario, and British Columbia, and practiced as a barrister in Nigeria and Canada. Judge Eboe-Osuji taught international criminal law as an adjunct professor at the Faculty of Law of the University of Ottawa, and has an extensive record of legal scholarship and publications, including the books titled International Law and Sexual Violence and Armed Conflict and Protecting Humanity. He is the editor-in-chief of the Nigerian Yearbook of International Law. He served as a legal expert to Nigeria's delegation to the ICC-ASP Special Working Group on the definition of the crime of aggression. He holds an LLB degree from the University of Calabar, an LLM from McGill University, a PhD from the University of Amsterdam, and a Doctor of University from the University of Middlesex.
Thank you so much, Angela. And with that, I will turn it over to the president. Following the president's remarks, there will be time for Q&A. You can enter your Q&A in the chat at that point, or your questions rather in the chat, and I will read out as many as I can, and the president will respond. So thank you very much. Angela, over to you, President.
Thank you very much, Dean Waters, members of the faculty, the students, Ladies and gentlemen, it is a great honor to be with you today. The last time I was at Windsor Law was in 1995. That was during the time of Dean Westmoreland Traore, who was also a good friend of mine, as are you, Dean. I was there on that occasion in person. In those days, global pandemics was something you only saw in science fiction movies. And now here we are using technology to do this. But it does work, as we can see. Now, there's a very naughty song by 50 Cent, as most of his songs are, about using technology. So let's not go there. But it's enough to say that we are grateful that technology is working for us on this occasion. Now, in the summer of 1998, following 3 years of preparatory negotiations and decades of studies, members of the diplomatic community and of civil society and jurists from around the globe convened in Rome to deliver a vision that was both tall and large, to be seen and felt around the world. It was a vision of a world in which atrocities that shock the conscience of humanity would no longer be committed against victims with the usual assurance of impunity that resulted from inaction, either due to willful indifference or even impotent outrage. It was no longer seen as good enough for the world to pound table in indignant condemnation and denunciation of the latest genocide or crimes against humanity, but then move on thinking or saying that nothing could really be done. That new vision was to establish an international criminal court as a permanent institution capable of looming large, as a real edifice of the rule of law at the international stage. It is meant to loom large in the consciousness of those inclined to commit such crimes. It is meant to loom large as a place of accountability, where they, however mighty they may be, will one day be compelled to answer questions about their conduct. And yes, it is meant to loom large as a place of justice, where the defendant would be acquitted of the charges against him if those charges are not made out on a standard of proof beyond reasonable doubt, following proper judicial inquiry. On the 17th of July 1998, that tall vision became reality with the adoption of the Statute of the International Criminal Court, named the Rome Statute, after the city where its text was on that day agreed to by 120 states. Some events remain in history as defining moments. Now, that was definitely one. A product of joint action amongst nations, the ICC was meant to be a court of last resort, whose jurisdiction arises only when the state concerned proves unable or unwilling to do justice within the national jurisdiction. In a manner of speaking, it is a rescue mission for justice, ensuring that justice does not become a neglected orphan in the territory of national sovereignty. The ICC's mandate is to try those who commit some of those unimaginable atrocities that shock the conscience of humanity. But let us call these crimes by their proper names. We are talking about genocide. We are talking about crimes against humanity. We are talking about war crimes, and we are talking about the crime of aggression. These are crimes that have devastated the soul of humanity frequently and for long, up until the negotiation and adoption of the Rome Statute. We can be even more specific in recalling the history of evil in the period leading right up to the adoption of the Rome Statute in 1998. It may be recalled that no less than 7,000 Bosnian Muslim men and boys were massacred in Srebrenica in 1995. The International Criminal Tribunal for the former Yugoslavia has pronounced their killing as genocidal. Talking about genocide, the year before, in 1994, about 800,000 Tutsis were killed in the Rwandan genocide. And about 50 years before that, 6 million innocent human beings were killed in a genocide in Europe because they were Jews. Let us also recall that beginning in 1991, Sierra Leone was engulfed by a brutal civil war that saw plenty of killings, rapes, sexual slavery, and the conscription of children into military use. And that civil war was also marked by a particular brand of cruelty and terror. It involved the heartless amputations of the arms of human beings by their fellow human beings, leaving the victims with disabling physical and mental scars that last a lifetime. It was a crime against humanity that left its very visible scars on that country, on our collective conscience and souls as human beings, even today. And we must recall that it was only in the early 1990s, shortly before the adoption of the Rome Statute, that apartheid came to an end in South Africa. Now, apartheid is a crime against humanity over which the ICC now enjoys jurisdiction. Just weeks before the adoption of the Rome Statute in 1998, President Nelson Mandela, an iconic victim of the crime of apartheid and a hero of that experience, reminded the world that there had been enough horrors that human beings had visited upon their fellow human beings. He observed that many of those horrors might have been avoided or at least minimized had there been an effective, functioning International Criminal Court. Now we have in place that International Criminal Court that Mandela had wished for, a permanent mechanism to ensure eventual accountability for those who subject others to such cruelty in future. Ladies and gentlemen, the Rome Statute entered into force in 2002 following its ratification by 60 states. As of today, 123 countries have joined up. It is essential that we encourage more states to ratify the Rome Statute in order to make the dividends of the ICC truly universal. And here, I need to recall that as a treaty-based institution, the ICC will only have true universal jurisdiction when all nations of the world have ratified the Rome Statute. Without that, some of the tragic conflicts that have vexed the world's attention, conscience, and morality are simply beyond the ICC's reach when crimes of atrocity are committed within the territories of those states that have not ratified the Rome Statute. It means that victims of such atrocities are left to languish outside the consolatory zone of justice. In that way, they are doubly victimized, first by the atrocities that they have endured in the first place, and then by the impunity that the perpetrators apparently enjoy after the fact. Ladies and gentlemen, during the 17 years of ICC's operation, it has done much more than many imagined it could do. The Office of the Prosecutor of the ICC has conducted investigations into 11 different conflicts in 10 countries. Court cases have been initiated against more than 45 persons, some of them heads of state. Crimes charged have included murder of civilians, rape, sexual slavery, conscription of children into military use, forced displacement and deportation, destruction of religious monuments, and election-related violence, about which I'll say more a little later. More than 10,000 victims have been admitted to participate in the ICC's proceedings and to request reparation for the harm they have suffered. This new focus on reparation or reparative justice represents a major shift in paradigms compared to the ad hoc tribunals for Rwanda and the former Yugoslavia, which were almost exclusively focused on punitive justice. The ICC's Trust Fund for Victims is implementing the court's first orders on reparation. What does that mean in actual terms? Now, for example, we can look at the case of Ahmadi, who pleaded guilty to the war crime of destruction of religious monuments in Timbuktu, Mali. The judges ordered a range of reparation measures tailored to the circumstances of the case. These included individual compensation to those whose livelihoods depended upon the protected heritage sites that were destroyed. Symbolic measures to signal public recognition of the moral harm suffered were also ordered. Also ordered were community measures aimed at restoring lost economic activity, as well as dissemination of Mr. Ahmadi's apology to victims in the main languages spoken in Timbuktu. In another case, that of Mr. Kitanga, the judges ordered individual monetary compensation as a symbolic measure, but also collective reparation in the form of psychological support, as well as support for housing, support for income-generating activities, and support for education. The overarching idea is that the reparation measures are aimed at addressing in a specific way the harm that victims have suffered as a result of the crimes for which the court finds the defendants guilty. If the defendant has means, these will be seized for the reparation. But if he is indigent, the Trust Fund for Victims can use voluntary donations received from governments as well as from private donors. And beyond the four corners of the cases in the courtroom, several 100,000 victims in Uganda and the Democratic Republic of the Congo have benefited from the programs of the Trust Fund for Victims under its assistance mandate. The assistance mandate of the Trust Fund describes the aspect of the Trust Fund's work that seeks to bring some relief to obvious victims of crimes, unrestrained by considerations of proof of guilt or not, beyond reasonable doubt, of the perpetrator for the harm that the victims suffered. These are only some of the accomplishments of the Rome Statute system that underscore the values of the ICC. I have argued in my own academic writings that the recurrent incidence of rapes during armed conflicts warrants judicial notice to be taken of that evil as something always to be expected during war. But let me be clear, the point is not to normalize or accept that brand of evil, an evil so vile. Quite the contrary, the idea of judicial notice is that it helps to ease the burden of proof of rape, for that burden often weighs disproportionately on the victims when the burden is left to be discharged in the ordinary way in a criminal trial. Whatever be the case, the Rome Statute and the ICC as its instrument of efficacy serve to counter the tendency of soldiers to see armed conflicts as periods of lawless jamborees in which they may commit sexual violence without accountability, possibly with military commanders allowing that to happen as part of the booties of war. Ladies and gentlemen, there has indeed been much to be proud of in the Rome Statute system so far, though we do not permit ourselves to celebrate at the court. We are not free to celebrate achievement because the ICC has faced significant challenges. These come in the manner of budgetary constraints for the scope of the work that the court must do, with challenges by way of inadequate cooperation from some states, challenges concerning fugitives that remain at large in circumstances in which there is very little that the court can do to arraign the suspects because we have no police force to search for and arrest fugitives. We also suffer challenges by way, as the Dean mentioned earlier, very aggressive political attacks on the court, precisely because it dares to want to do its work. But we, the functionaries of the court, also have our own share of the blame, some of it. We could do a lot more to explore ways in which we could make the proceedings more efficient, make the court feel stronger to the world. Yes, indeed, there is much room for improvement. This is so, of course, for any human institution. Even the best judicial systems in the world face their own challenges for improvement. It is for that reason that the court has, under my leadership, fully welcomed and embraced the idea of a review of the entire Rome Statute system, roots and branch review, as it were. That is to say, a review of the court itself, as well as the supporting structure intended for it in the manner of the Assembly of States Parties, in order to see how the entire system may be improved and strengthened to serve its mandate of humanity more effectively. Still, we must not allow the impressions of these challenges to obscure the huge difference that the court has made in our world since its creation, the creation of the court. Here, I must stress that even with all the challenges that it has faced, the ICC has fundamentally changed the way the world looks at accountability for atrocity crimes. On the occasion of the UN Secretary General then, the late Mr. Kofi Annan, said this, quote, "Until now, when powerful men committed crimes against humanity, they knew that as long as they remained powerful, no earthly court could judge them," unquote. That observation captured the essential purpose of the ICC and its enduring value to humanity. With a permanent international criminal court in place, even the most powerful men, and they're often men, can no longer be certain that they will get away with impunity if they commit against their fellow human beings these acts that the Rome Statute forbids. Even if prevailing circumstances seem to make impunity possible for the time being, the perpetrators and their accomplices will now recognize that their impunity will always be illicit and that it will not endure. And with that comes the ICC's correlative value of deterrence. This value cannot be overemphasized. There are indeed many reasons to insist that the mere existence of the ICC does truly serve, at a minimum, as an inconvenient obstacle to the free will of those inclined to commit crimes of atrocity. This is particularly evident in the context of elections in Africa, the continent of my own birth, where politicians and their thugs had no qualms about winning elections through violence. Since the advent of the ICC and its first cases concerning election violence, there has been a noticeable reduction of that deplorable phenomenon that tends to blight the experience of democracy in Africa. I am in a position to say this in this connection. I was the presiding judge in a case where an expert witness had testified that prior to the 2007-2008 election in Kenya, past elections had been marred by ever-increasing incidences of political violence. But following the ICC proceedings that addressed the 2007-2008 violence, subsequent elections in Kenya have seen a marked decrease in violence. I have also been told directly by leaders of states, government ministers, and civil society leaders that the ICC's existence was a very significant factor in preventing bloodshed in the context of elections in their countries. This is because everyone had seen that whoever would commit such violence might end up before the ICC to answer for their actions. That deterrent value alone is enough of a return on the ICC investment, I'm bound to argue. These are, of course, some of the values of the ICC. There are also those, of course, who would try to diminish ICC's deterrent effect by asking how do you measure deterrence? It is true, of course, that the measure of deterrence is not stuff of precise science, but there are ways to appraise it. First, one such way is in the testimonies that we have received about politicians being more careful in their conduct during elections, as I indicated earlier. This is considering that in the period before the ICC, electoral violence was a free-for-all affair. In that regard, as indicated earlier, some leaders of states have testified directly to me. Deterrence can also be measured by the incidence of political leaders who refuse or are reluctant to leave office out of fear that someone may send them to the ICC to face trial for some of their actions and omissions. And yes, deterrence can be measured by the very incidence of the trenchant political attacks that the Dean and I alluded to earlier. Yes, it is very significant that officials of very powerful nations would see the ICC as their country's quote-unquote worst nightmare come to life. And others of that kind have been known to call the ICC quote-unquote a monster that should not be allowed to thrive. It is correct to dismiss these descriptions as flights of truly overdone melodrama. Still, the significance of the underlying concern should be lost on no one. We also know that beyond the propaganda against the ICC, there have been many leaders who have expended significant funds and their own goodwill in campaigns to undermine the court. But why go through all that trouble unless you could see the ICC as a real obstacle to your impunity? If the ICC is not effective, then leave it alone to do its work. I had occasion to share some reflections on the 27th of January this year, on the occasion of the 75th anniversary of the liberation of Auschwitz. On that occasion, I offered the following thoughts. I reflected on the guiding ethos of the New World Order following the Second World War, which was coeval with the Holocaust, was engraved in the commitment of quote unquote never again. It bears stressing, of course, that the Holocaust remains the paradigm testament of the human capacity for evil. As a global undertaking, however, never again was meant to stand against human atrocities of even lesser scale, so that humanity is never again to endure atrocity on the scale of the Holocaust. But did never again really mean anything? In light of that question, it may be significant that in the decades following the liberation of Auschwitz, the world witnessed other atrocities in the forms of crimes against humanity, war crimes, and yes, genocides. It was to take events like the genocide against Rwandan Tutsis and the crime against humanity committed in the former Yugoslavia for the world finally to take firm action that gives concrete instrument to the never again undertaking. That firm action was the adoption of the Rome Statute in 1998, and that concrete instrument is the International Criminal Court that was therein created. Now, as an actionable undertaking, never again is a defiant pledge indeed. It communicates a promise of arduous struggle against an opposing foe. This instance, that opposing foe is evil. The ICC is an actionable instrument of that defiant pledge, that arduous struggle against evil in our own time. It is in that light that the trenchant political attacks against the ICC oddly makes sense. Yes, of course, ICC must be allowed to do its work undistracted by attacks directed against it, in obvious strategy to intimidate. But it may well be wishful thinking to hope for an end to that kind of conduct, as there is no readily available strategy to stop them, short of those occasions when a particular attack crosses the line into the territory of a distinct offense prosecutable pursuant to Article 70 of the Rome Statute. We are thus left to recognize the consolatory significance of these political attacks. It is in the nature of the ICC's mandate to attract such resistance as is inherent in the very nature of the arduous struggle that was always contemplated in the Pledge of Never Again. And that resistance shows that the court is making a difference. It shows that the court cannot be ignored by those who may have an interest in the preference to leave innocent victims at the mercy of heinous crimes, or worse still, those who may be inclined actually to perpetrate such crimes. Yes, it is in the very mandate of the ICC to get in the way of such atrocities, to stand against them. And yes, it is better for the court to draw the ire of political forces, of potential forces of these violations, and of those who see an interest in condoning them, than that their hellfire is allowed to reign unobstructed upon defenseless, innocent victims. Thus, some comfort may be taken in the realization that the political attacks against the ICC are a veritable signal that the court is doing its work as it should, precisely by engaging in the very arduous struggle that is in it, in the vow of never again. From the perspective of the ICC, that vow of never again is a shared responsibility regarding which the ICC stands ready to play its own part. That part requires the ICC to put itself between the victims and the atrocities that the world had in mind when creating the court, even if this means broking political attacks against the court itself. And for its part, the world must continue to support and nurture in the most robust way that institution of accountability that it established as a monument to the actionable vow that the world will never again allow our shared humanity to endure a genocide, crimes against humanity, war crimes, and the crime of aggression without effective objection. The ICC remains one of the best instruments we now have in the pursuit of that objective of effective objection, while still remaining work in process. We must all spare no effort in supporting it. And I thank you.
Judge, thank you so much for those insights. I'll turn it over to Mélanie to thank you formally. Go ahead, Mélanie.
Hi, thank you so much, Mr. President. As you mentioned earlier in your speech, at the 75th anniversary of Auschwitz Liberation Reflections, you once said, "Did never again really mean anything? Or was it merely a self-serving salve to the world's apathy?" Those words resonated particularly with me because they highlighted the importance of approaching the law with passion, with resilience, with accountability. We in the legal field have, or will have for some of us, the privilege of serving and helping others, and therefore also the duty to resist apathy. I know that I personally, and I believe everyone here as well, will strive to follow in your example and continue onwards with that message in mind. On behalf of the University of Windsor Faculty of Law, the Black Law Students Association, and the International Law Society, we would like to thank you for speaking with us today, Mr. President. Thank you for joining us virtually in these unusual times. Your work with the court in regards to crimes against humanity, war crimes, genocides, and much more is incredibly important. And as someone who is fascinated by international affairs, it has truly been an honor to hear you share your experiences. Thank you so much for all the work you have done and for taking the time to be with us today. We would love to have you join us again on campus at the Windsor Faculty of Law in the future, but for now, thank you for joining us virtually, Mr. President.
Thank you very much.
Merci, Mélanie. The Q&A is now available in the chat, so I invite you to post questions in the chat, and I will read those. I'm not sure if you caught that, so I'm going to repeat what I just said. The ability to post questions in the chat is now open. So I invite listeners at home to post their questions in the chat. We have about just less than 20 minutes for Q&A. And I know there are some international criminal law students with us today. And so, they should feel free, amongst others. This is a lecture that's always open to the public. So you need not be an international criminal law student to ask a question. I'm sure my old friend will be happy to entertain any questions. So please do post them in the chat. While you're doing that, I do have a question from my colleague, Professor Sarah Wharton, who does teach international criminal law. And she asks, do you think that the court should take advantage of Article 3.3 of the Rome Statute to sit in locations other than The Hague, in particular to locate its trials closer to the communities in which the crimes were committed. And do you think from a practical standpoint, this is something that we are likely to see? And maybe just to that question, I would note that the Supreme Court of Canada fairly recently held hearings in Winnipeg. So there's some precedent on a national scale here. Judge, go ahead.
Well, that's fantastic to know that the Supreme Court, that must be the first time, was it?
It was indeed.
It held hearings in Winnipeg.
Yeah,
yes,
right.
indeed. Let me, that's, Chris, that answer is a no-brainer. Sorry, the question for me, the answer is a no-brainer. The answer is absolutely yes. That's my view of what needs to happen. In fact, just so you know, we had tried it. We had attempted to do that in the Kenya cases when I was presiding. We wanted to open the hearing in Nairobi or Arusha at the time, but it didn't work because at the time the rules that allowed it required all the judges to, 18 judges to vote on the matter. And the vote didn't work out the way the judges actually in the case, the three of us in the case wanted it, but there was a vote. The colleagues had different reasons for voting against it. Now the rules have now been changed. Had I known this case was, that question was coming, I would have given you the precise way in which the rules are changed, but now the rules no longer require all the judges to vote on the matter. I think it's easier to do for judges who are inclined to doing it. So the short answer to that question is yes, it's a very desirable practice. I'm fully in favor of it. If it had worked the last time we tried it in 2013, I think it was 2000. Yeah, I forget the date we tried. We wanted to do that. That would have been we would have done it before the Supreme Court of Canada did that.
Very good to know. Thank you. Our next question is from Dimitro Botov, who writes, on September 2nd, the United States imposed financial sanctions on senior ICC officials. Global Affairs Canada has issued a statement that they are disappointed and concerned about ICC personnel being targeted for the important work that they do. The sanctions were triggered by an investigation into alleged war crimes by American soldiers in Afghanistan, even though America has not joined the ICC. My question is in two parts. First, would these sanctions jeopardize the delivery of justice or further investigation into the alleged war crimes? And second, what changes would you like to see the ICC adopt in order to assure its autonomy from world players and to maintain freedom of operation? Thank you.
Can you get the second part again? Can you?
Sure.
Just so you know, Chris, we're getting these little blinks in transmission from time to time. Sometimes they stay for a longer time, others. So I'm able to hear some, not all the time, but the second part of the question.
Got you. What changes would you like to see the ICC adopt in order to assure its autonomy from powerful players?
Right. First of all, we don't use the word sanction to describe that, and I may have explained this before in the past. Personally, sanctions are accepted measures in international law to go after human rights abusers, terrorist organizations, money launderers, and such kinds of folks. It is a very bizarre and strange perversion of that idea to use it to go after an international court that's seeking precisely to ensure respect for human rights and accountability and bring justice to victims. It is a perversion of the concept of sanctions as we have accepted it in international law. So we need to put that out there for what it's worth, but they call it what they choose to call it, so we can use their language, of course. It is certainly a very worrying, more than worrying development in a lot of ways. the first part of the question, does it interfere with the delivery of justice? As I understood the question, it does. It does, and it does so beyond just this instance, because it now sends an example to the world, and that example comes from a very odd place. If we are talking about a country that has a reputation for extended human rights violations, where you roll your eyes whenever they show up, that's one thing. But if you're talking about the United States, known to be a standard bearer in the best of times about the rule of law and respect for judicial independence, coming and so powerful, it sends an example to the usual suspects of this kind of conduct that are known to do stuff like this, to say it's okay to do it. After all, the United States has done it, so why not they? So that is the way in which it destroys, seeks to damage the architecture of respect for human rights and delivery of justice, not only, by the way, at the ICC, but at the national systems as well, because this thing has a very pervasive reach. If you could do that at an international stage, what stops it's clearly a signal for countries inclined to do so at home to do it as well, in addition to the ICC, international realm. So that's why it is very, very dangerous. We cannot begin to, describe the scope of this behavior. Right. Now, about changes that could be made, it's a very technical question. It's not always easy to do these things, but we depend, as you know, on the world as it is to operate. If this has happened, it is time for lessons to be learned about how the court is to protect itself going forward, knowing that this precedent has been set, knowing that others who are able to impose sanctions, quote unquote sanctions, using their own means and power to do so, may want to try this again in future. So it is certainly experience that we must learn from.
Thank you, Judge. Next question is from Rachel Ward. We know that corporations have always and continue to commit, aid, abet, and be complicit in international crimes. And we also know that corporations frequently have greater wealth and resources that can be made the subject of reparations to victims. A type of justice which, as you discussed, sets the ICC apart from other ad hoc tribunals, from ad hoc tribunals. Do you think that the ICC will eventually see an amendment to the Rome Statute, extending the jurisdiction of the court to corporations? Or do you think the absence of corporate liability standards globally will continue to bar the ICC from seeking such an amendment? And there was a similar question from Kay Clara, who was asking about corporations and ecocide, or environmental degradation.
Now, Chris, one second, please. That question came out, you froze for a long period of time.
I'm so sorry.
Let me try and rephrase. Let me see if I could guess where it might be going. Is it about whether ICC could exercise jurisdiction over corporations?
Yes. And do you think that an amendment would be required, and so on? And there was a similar question about that in the environmental context.
Yes, thank you. Those are very critical and very important questions, and the premise of them clearly understood. Corporations are very powerful players on the international stage, and it is fair to say that some corporations are more powerful than the state parties who are parties to the Rome Statute. And of course, in the minds of many people, like the person who asked that question would be, well, if you would hold potentially states accountable for violations, why not corporations? And that's a very important question. As you may know, an attempt was made to include corporations within the jurisdiction of the Rome Statute, but it didn't work because, as I understood it, during the negotiations in 1998, the delegates ran out of time to take it on. and so they defied it. So when the story of why it wasn't there is told, it's not because there was a deliberate decision agreed to exclude corporations. It's simply because they didn't have enough time to get a deal with that question. So it may well be something states may take up again in future. And it also goes with the environmental concerns. I get that question often, and my answer is it's for states parties to amend the Rome Statute in every way they think makes sense, and usually academics help them to inspire them to see ways to do it. So there you go, Chris. So once these amendments are made, and there have been amendments along the lines in the Rome Statute since its adoption, but amendments made, the judges will, and the official, the prosecutor, will execute the mandate given to them.
Thank you. Judge, our next question is from my colleague and our Associate Dean Academic, Beverly Jacobs. I'm going to try publishing it, and hopefully that will appear in a way that makes it easier to follow. And is that now available? Do you see it?
I can't see it.
Okay, well, I'm going to read it out then as well. It has been confirmed by the National Inquiry on Missing and Murdered Indigenous Women that Canada has committed genocide against Indigenous peoples, especially Indigenous women. The history of violence against Indigenous peoples that include the residential school policy, as legislated in the Indian Act and contracts with religious denomination of churches, is well documented by survivors. Are you able to follow so far, Judge?
Again, that's one of those times when, not because clearly that's a sensitive question, but that's not why I didn't hear it. Just that you froze.
Okay. I'll keep going. The residential school policy is a holocaust against Indigenous peoples. When there's evidence of this against the state, how does one bring this attention or matter to the ICC?
Now, first of all, the residential school program happened such a long time ago that the ICC does not have jurisdiction. As you know, the jurisdiction of the ICC started in 2002. So that's one way to look at that matter. But wherever there's allegation of violation by a state party, the usual thing complainants have done, or those interested in it, would be bring the matter to the attention of the office of the prosecutor. And that's why how allegations have been dealt with. The prosecutor does get from all over the world many complaints that I'm aware of, because oftentimes people send these emails to me thinking I'm the prosecutor, so I get to know complaints being sent, and then we will let them know that any complaints of that nature will need to go to the OTP, and then the prosecutor will take it through the internal processes. I don't know what they are, and then decide whether there's enough merit to complaints to take it forward or not. So that's one way to deal with complaints. Other instances would be if the Security Council refers a specific complaint to the ICC, and that has happened in the case of Darfur, for instance, and Libya. The referrals from the UN Security Council, so Security Council can refer matters to the office of the prosecutor, as well as states themselves can make the referral to the office of the prosecutor as well.
Thank you, Judge. The next question, changing tack slightly, is from Cassandra Wolf, who asks, what advice would you give to young lawyers who want to eventually practice in the area of international criminal law?
That is a very important question. I mean, the idea is, first of all, my advice is don't give up the hope or the dream. Keep focused on that. Do other things in the meantime to shore up the experience you have. I would encourage studies. Before we got on here, but it means I'll come back to this. I'll encourage graduate studies, master's degree, the doctorate degree. Grace, you did yours, so did I. Don't leave it at JD. I know the Canadian universities have thought, well, if we change LLB to JD, that makes it a graduate law degree. No, it's not. An international system, a JD remains a first degree in law. So the graduate degree in law is your LLM and your PhD after that. The reason why the JD is not considered as a first, as a graduate degree in law on the international plane is because you may have people from other countries who have not only the LLB, but also on top of that, LLMs. So you cannot ignore their LLM and then drop down your graduate degree at the JD, first degree in law. So take it beyond the JD, get your master's degrees and PhDs, internships, and then keep on trying and don't give up. That's no magic formula to it. One thing I tell the interns and younger lawyers who come here, usually interns who pass through my office, is just look at it in terms of you are a pilot flying a plane to destination. There are times when you have to drop altitude, right? And there are times when you have to take detours just to avoid some stormy weather somewhere or obstacles or mountains along the way. So that's what needs to happen sometimes. You may take that job that may not be your ideal job for the time being, but ultimately, if it adds to the experience you will have down the line, that it does help the recruiters will look at that and consider the value it will have. Now we're not hearing you at all.
Yeah, thank you, Judge. And a final question is from Matea Selders, who asks, I'm going to shorten it just to make it easy for us to communicate this, but how do we convince non-signatories who are attempting to avoid justice that becoming part of the ICC regime is in their best interest? How do we convince non-signatories?
That is a brilliant question. I know it's longer, but you capture the essence of it. What example I give is this. There was a gentleman who used to be the AU, the president of the African Union Commission, Mr. Jean-Ping. When he was the African Union Commission president, he had a reputation for, being very rough on the ICC. He had a reputation for not wanting to hear about the ICC. That was his reputation. Now he left that position and returned to his country, I think from Gabon, and ran for election. And apparently there was some funny doings apparently in that election. And what does he do? He remembered the ICC, so that we're going to going to go to the ICC to complain about what happened. So here he has somebody who the day before who didn't want to hear about the ICC, and the next day he wanted to take him out to the ICC. The point is that ICC stands for justice for everyone. Power, I liken power to something of riding a tiger. It's an unruly animal. When it's going well for you, it's great, but when you fall off that animal, then it can be a little tricky. So ICC serves to protect everyone. Doesn't matter whether you are the devil facing human rights violations or the angel. ICC wants justice done. So it is in the interest of everyone to support that, because you may feel powerful today, but then tomorrow when you retire from power, you may need that protection. So it's there to support everyone.
Very good. Well, Judge, thank you again for these insights. As Melanie has already very eloquently stated, we've all benefited from your bird's eye view of international criminal justice. And I'm very grateful that you made the time for us today. To those who posed questions that I was unable to get to because of time restraints, my apologies. There were some very good questions, and I'm sorry that we weren't able to get to them all, but I think we did get through some really good ones, and I appreciate very much your answers. For members of the International Law Student Society at Windsor Law and for the Black Law Student Society Windsor chapter, I invite you, after I close now, to join us for a brief reception for Judge Eboe-Osuji, and we'll continue our chat a little bit more. But for now, Judge, am I correct in thinking you're wearing a McGill tie?
You are correct indeed.
So my only criticism of your talk is that well, not a criticism, but as a way of moving forward, shall we say, we'll have to send you a Windsor Law tie or a University of Windsor tie. And but I always appreciate the fact that you're grounded in not only two national systems as well as this international.
But you can't complain.
That's true. As a proud graduate of McGill as well, I won't complain. You're right.
There you go.
Okay, Judge. So we'll sign off now. And my very best and thanks to everyone who joined us from both Windsor, Toronto, and around the world. Take care, and Judge, we'll see you shortly in the reception.
Thank you very much.
Thank you all. Take care.
Thank you, Melanie. Thank you, Angela.